Hello, and welcome to another edition of Legal Hotline Q&A. I'm Laura Farley, Deputy General Counsel for the Virginia Association of Realtors. Today I want to talk to you about the lead-based paint regulations and the law that relates to them. And I know that many of you are going to say, well, but wait a minute, Laura, those have been around for decades, so why are we talking about them now? And the reason I want to talk about them with you today is because in Virginia, we've seen an uptick in compliance enforcement from HUD and EPA. I've been getting a number of calls from our members who say that they have had EPA or HUD investigators in their office who have asked to see their copy of the lead-based paint hazard forms, the disclosure forms, and they want to see that they've been signed by everybody. So we're going to start today with a bit of an overview of the law, what your obligations are, what sanctions might be issued against you if you fail to comply, and then how this goes together with the Code of Ethics. First topic that I want to talk to you about today is the underlying law, and that is found in 42 U.S. Code 4852D. And in that section, it talks about the fact that before a purchaser or tenant is going to be obligated under a contract, the seller or landlord shall, first, provide a lead hazard info pamphlet from the EPA. Second, disclose the presence of any known lead-based paint or lead-based paint hazards and provide any lead hazard evaluation report that they may have available. And finally, in sales transactions, permit purchasers a 10-day window to conduct a risk assessment or inspection. And this 10-day period can either be waived in writing or extended by or reduced by agreement of the parties. The next part of the U.S. Code that I want to talk about deals with the compliance assurance that's required under these laws. And that says that whenever a seller or lessor has entered into a contract with an agent for the purpose of selling or leasing a unit of target housing, the regulations promulgated under this section shall require the agent, on behalf of the seller or lessor, to ensure compliance with the requirements of this section. So what does all of that mean? Let's start by talking about the section in the regulations that deal with what exactly is an agent. Under 40 Code of Federal Regulations, Part 745, which is the lead-based paint poisoning prevention in certain residential structures section, it says that an agent means any person, any party who enters into a contract with a seller or lessor, including any party who enters into a contract with a representative of the seller or lessor for the purpose of selling or leasing target housing. This term does not apply to purchasers or any purchaser's representative who will receive all compensation from the purchaser. Okay, well, what does that mean? You have a couple of different scenarios. You have what is a fairly common transaction where a listing agent has put the property on the MLS and is offering compensation to any buyer agent or a cooperating agent or broker who brings a buyer to the transaction. In that case, both agents, the listing agent and the buyer agent, who's receiving their compensation from the seller's representative through the MLS, are going to fall under the definition of agent in these regulations. In a different situation, maybe when you have a for sale by owner situation, you may or may not meet the definition of agent. And what does that mean? Well, if during the for sale by owner process, the owner agrees to pay the commission to the buyer agent, then that buyer agent would be considered an agent under the regulations. If, on the other hand, the seller says, I'm not going to pay you, Mr. Buyer Agent, your buyer's going to have to pay you directly, the buyer agent is exempt from these regulations because they don't meet the definition of agent under the federal regulations. Before we move into what the regulations and requirements are, I want to talk quickly about some exemptions from the lead-based paint regulations. There are 4 that I'm going to talk about, and the first is if there's a foreclosure sale. The second is leases for houses that have been found to be lead-based paint free by a federally certified inspector. The third is short-term leases of 100 days or less that cannot be renewed or extended. And the final one is renewals of existing leases where disclosure has previously occurred and no new information is available. In these situations, there is no requirement that these regulations and these required disclosures are provided. So now that we've discussed who these regulations apply to and when you're going to be obligated to comply with them, let's talk about exactly what it is that you have to do. So the regulations, 40 CFR 745.113, requires it's titled Certification and Acknowledgement of Disclosure. So in this, there has to be a lead warning statement, a statement by the seller disclosing the presence of known paint or lead-based paint hazards or indicating that they have no knowledge and providing any additional information regarding this that they may have. List any records or reports available to the seller that have been provided to the purchaser, and if there are none, indicate that on the form. A statement by the purchaser affirming receipt of this information and pamphlet. A statement by the purchaser that he or she has, first, received the opportunity to conduct an inspection, or, second, waived that opportunity. And then when one or more agents are involved in the transaction, there must be a statement that the agent has informed the seller of the seller's obligations and that the agent is aware of his or her duty to ensure compliance with the requirements. The form must have the signatures of the sellers, the agents, the purchasers that certify to the accuracy of their statements to the best of their knowledge, and it also must include the date of the signature. Document retention also falls under this section, and that provision requires that sellers and any agents, that's the definition of agent, which means that you've received compensation from the seller, keep a copy of the completed attachment for at least 3 years from date of sale or 3 years from the commencement of the lease. Let's shift gears slightly and talk about what the agent's responsibilities are, and these can be found in 40 CFR 745.115. In this section, it says that each agent shall ensure compliance with all requirements by informing the seller or lessor of their obligations and ensure that the seller or lessor has performed all activities required or personally ensure compliance. If the agent has informed the seller or lessor of their obligations, they will not be liable for failure to disclose the presence of lead-based paint or a lead-based paint hazard. So the fastest and easiest way to make sure that you can reduce your risk and reduce your liability is just to ensure that the seller is aware of their obligations. Once you have done that, if you have informed the seller or their lessor of their obligations, you've reduced your risk and you've minimized your liability, because the law specifically says that any agent that has informed the seller or lessor of their obligations is not liable for the failure to disclose the presence of lead-based paint or lead-based paint hazards. So now that we've talked about what your obligations are, let's talk about what could happen if those obligations aren't met. And 40 CFR 745.118 discusses what the sanctions or what the liability could be for agents and sellers or lessors who don't comply. And the first one deals with with individuals who knowingly fail to comply that will be subject to civil monetary penalties of up to $10,000 per violation. The second is that anyone who knowingly fails to comply will be jointly and severally liable for treble damages. Let's break that down and explain what that means. Let's say, for example, that I'm a buyer agent, you're the listing agent, and we both forget to tell the seller about their obligations under the lead-based paint laws and regulations. So the seller fails to disclose, fails to provide the disclosure form, and fails to provide the EPA pamphlet to the buyer. The buyer moves into the house with a young child who then suffers health problems because of the lead-based paint that was in the property. The buyer turns around and they sue the seller, they sue you, and they sue me. And so all three of us are sitting there and we're liable. And the jointly and severally liable means that if there is liability and there are damages, as far as the plaintiff is concerned, as far as the buyer is concerned, it doesn't matter which of the three of us pays that money, but they're going to get paid that money. Since there are three of us, let's say that all three of us were found to have violated the statute and all three of us are now liable, as far as the court is concerned, I could pay 100%, you could pay 100%, the seller could pay 100%, we could each pay a third, I could pay half, and each of you pay 25%. The breakdown doesn't matter as far as the court and the buyer are concerned, so long as the buyer gets the full amount of the damages to which they are entitled. So that's what jointly and severally liable means. Let's talk about treble damages. What does that mean? Treble damages means that whatever the damages are to the buyer, in this case, or the plaintiff, whoever, whether it's the buyer or the tenant or whatever, whoever it is, the court will take those damages and multiply it by 3. So for example, if the buyer is able to prove that they have $100,000 in damages, the liability to those who failed to comply with the regulations would be $300,000. And the reason for that is that lawmakers will sometimes take certain situations where they see that there's a public policy reason for saying this is something that's really important. Sometimes it's just that we want to make sure that we really drive home the point that this is important, and damages to anybody are so severe that we really kind of want to make it hurt to those who break the law in this particular area. And sometimes it can be that they say that this is the easiest way. Sometimes there are some laws that people say, well, it's the cost of doing business. I'm just going to break the law, run the risk, and pay the penalty. Something that a lot of us will do sometimes. If you're speeding down the road, you know you're breaking the law. You know that you may face a penalty, a fine for doing that, but you kind of do an analysis and go, I'm really in a hurry, so this time I'm willing to take that risk. Well, if those fines were triple what they normally are, you're probably a little less likely to take that risk. And that's what this situation is here. So, to sum that up again, jointly and severally liable means whoever is found in violation, any one of them can pay whatever proportion as long as the plaintiff gets the full amount. And treble damages, that's going to be triple whatever the proven damages are. So in addition to the civil monetary penalties that you may have to pay and those treble damages you may have to pay, the courts can award court costs, attorney's fees, and expert witness fees to any prevailing party in one of these cases. So that's just over and above. Now, I know a lot of you are going, well, but wait a minute, Laura, you've now told me that I could be facing a lot of these penalties if I fail to ensure compliance with these regulations. But the Code of Ethics prohibits me as a buyer agent from talking to a seller who's represented. And you're right. Article 16 of the Code of Ethics, Standard of Practice 16-13, says all dealings concerning property exclusively listed or with buyer tenants who are subject to an exclusive agreement shall be carried on with the client's representative or broker, and not with the client, except with the consent of the client's representative or broker, or except where such dealings are initiated by the client. So how does that fit with the lead-based paint regulations? Well, oftentimes we'll see a listing agent will get that lead-based paint disclosure form signed by the seller, and they will upload that along with the EPA pamphlet into the MLS documents field. Well, in that case, you know that the seller is aware of their obligations because they've already signed the form, which is required of them. And if they filled that form out, they've listed any hazards that they're aware of. They've provided any documents. They've listed the documents that they may be aware of. So you know that they're aware. So you know that compliance has been met. If you don't receive that form, pick up the phone or, break out your laptop or computer and get in touch with the listing agent and say, hey, listing agent, I know that you're aware, hopefully, of the lead-based paint regulations, and as you may or may not be aware, as an agent who's receiving compensation from the seller, I have an obligation to make sure that they are aware of what they have to do. And so I want to make sure that I've met my requirements. I'm going to reach out to the seller and I'm going to let the seller know that they have an obligation to provide this form to the buyer. And that will take care of that. So just as a quick recap, if you receive compensation from the seller, and whether that's from the seller directly or whether that's from the seller through the listing company, so it's indirect compensation, you are an agent for the purposes of the lead-based paint regulations. And agents have an obligation to ensure that the seller or lessor is aware of their obligations to disclose these possible hazards. They have to fill out the form, they have to provide the pamphlet. And that form has to be signed by the seller, the purchaser, and any agent who receives compensation. So if you're receiving compensation, you need to make sure that form is filled out. If you fail to do so, you could be facing civil monetary penalties of up to $10,000 per violation. You could be jointly and severally liable for treble damages, and you could be liable for the costs, attorney fees, and expert witness fees of any plaintiff. All right, everybody, don't forget, VAR also offers a couple of forms, and you can get these forms from our website. It's Form 1300 and 1350. Those are the lead-based paint disclosure forms. They contain all of the required provisions. You can also find those forms on EPA's website and HUD's website if you're looking for them. Have a great day, everybody, and stay safe.